Howdy folks, Suno has responded to the lawsuit officially. I did it actually a few weeks ago. I've been busy, a lot of travel, some other things going on in my personal life keep me from creating content, but I'm finally able to carve out some time to talk about what Suno has to say about the lawsuit in an official manner. So we've got the answer of defendant Suno to the complaint. I want to walk through that. I got a lot of highlights, and I think there's some really compelling stuff in here. I think, juries, the inconsistency of the U.S. court system today aside, I think legally Suno has a fantastic case. I love the response, but in our crazy ass world today, we have no idea where this is going to go. So let's take a look and see what they're saying. For starters, preliminary statement, Suno comes in and defines what the tool is. It's an artificial intelligence powered tool for making new music. It's designed for originality, and that is how real people in the real world use it, to create new songs that didn't and often couldn't previously exist. Notice the little jab there. This is how real people in the real world use it. Not folks trying to hack it and pasting copyrighted lyrics to try to copy existing works. That's not what the tool is designed for. Unethical behavior on the part of end users is not Suno's responsibility. They go on, like a human musician, Suno did not develop its capabilities in a vacuum. It is the product of extensive analysis and study of the building blocks of music. What various genres and styles sound like, how those genres and styles are harmonized and structured, the timbre of instruments, the vocalizations, etc. Lots of things. Suno is defining how people learn music. These genres and styles, these recognizable sounds of opera, jazz, or rap are not something that anyone owns. Shots fired. You cannot own genres, styles, or feel. That's an important thing. What in the pink here, or the red, depending on your color vision, what Suno is saying is that the plaintiffs, the record companies, seek to shut Suno down. Calling it like it is. Record companies is trying to shut them down. Or, in reality, they're trying to get their cut. The record companies frame their concern as one about copies of their recordings made in the process of developing the technology. That is, copies never heard or seen by anyone, made solely to analyze the sonic and stylistic patterns of the universe of pre-existing musical expression. So that section here is kind of important because they're admitting that they made copies of music, copies that were never heard or seen by anyone. If you want to be really picky and anal, like so many lawyers are, you could say, you mean no one at Suno actually heard the music you copied? So, lawyers can be so incredibly unethical because all they care about is winning in many cases. Copies never heard or seen by anyone. The intent here is that the music is being downloaded to be analyzed to train tools. It's not being downloaded to reproduce or to redistribute or to charge money for. So the record companies say it is they're concerned about copying of music. Okay, but what the major record labels really don't want is competition. Where Suno sees musicians, teachers, and everyday people using a new tool to create original music, the labels see a threat to their market share. I got that in red because that's like a punch. It's like a good jab or uppercut that Suno was trying to spit out there. They're just painting the record companies to be the bad guys here, the vindictive, attacking, greedy entities. Suno will ultimately prevail in this litigation because the values that copyright law embodies and protects are Suno's values, incentivizing innovation in the service of enabling more expression of more ideas by more people. Plaintiff's lawsuit reflects the opposite values, an attempt to misuse intellectual property rights to shield incumbents from competition and reduce the universe of people who are equipped to create new expression. That's the big one. Suno is saying we are trying to do what's right, what's good to help people. The record companies are trying to muzzle that, to shut it down. And I absolutely agree with Suno on this one. Moving on, the technical foundation of that engine of creation is an underlying model of how music works. The model is a type of computer program known as a neural network. It was constructed by showing the program tens of millions of instances of different kinds of recordings. From analyzing their constitutive elements, the model derived a staggeringly complex collection of statistical insights about the auditory characteristics of those recordings. What types of sounds tend to appear in which kinds of music, what the shape of a pop song tends to look like, how the drum beat typically varies from country to rock to hip hop, what the guitar tone tends to sound like in those different genres, and so on. This whole paragraph is talking about learning, about how music is broken down into pieces and how the models learn that, just like humans do. When you want to create some music on your own, you want to sound like a certain musician, you want to learn a certain style. What do you do as a musician? Well, if you're smart, you listen to a bunch of music that you like, that you want to copy or emulate. And then when you play it, you're creating new music based on everything you listen to. What did that guitar player do? Where were they on the fretboard? How much did they bend the pitch? What stomp boxes or effects did they use? If you're a singer, you're listening for vibrato and volume and articulation and diction, etc. We as musicians listen, we copy, we emulate, and then we create something new, our own new version of a cover song or an original. But we have to study and analyze the music to understand how it works in order for us to create something new. That's what Suno is doing. Their tool is doing that, just at massive scale. But because it does something faster doesn't mean it's suddenly illegal or wrong. It's called technology. Scrolling down a hair here. So Suno goes on. To be clear, the model underpinning Suno's service is not a library of pre-existing content outputting a collage of samples stitched together from existing recordings. Instead, it is a vast store of information about what various music styles consist of, used to generate altogether new auditory renditions of creations in those styles. Again, Suno is not copying, it's not sampling. It's understanding, it's learning, it's analyzing everything that makes up music. And then when asked, it prompts and creates new audio files, new stuff based on its training. It's not sampling, it's not copying, it's not duplicating. It is reproducing the concepts that make up music, the math, the physics, the tempo, the emotion, dare I say. Okay? But people have to understand that. Plaintiffs' apparent efforts to misuse the tool to generate renditions of pre-existing songs are both unrepresentative of what real people do with Suno and a flagrant violation of the rules governing use of the platform. So what Suno is saying here is that the record companies or their lawyers or their people broke the law by trying to make Suno break the law. Those folks copied and pasted copyrighted lyrics into the tool, a violation of Suno's terms, and a violation of copyright law in general. Again, end users are the ones that are misusing the tool to try and replicate something, and they're replicating it poorly. They're not creating perfect copies. This is not a threat to the record company's content or the internet or the world at large. So that's a big deal. It's a violation. Suno's tool is being misused by people to try to make it do things it wasn't designed to do. Back to the case here. The only act that plaintiffs contend was unlawful is Suno's allegedly having made a copy of copyrighted sound recordings as part of the process of training the model. What does that mean? So in the entire lawsuit, the only actual legal claim of Suno breaking a law of some kind is that Suno supposedly copied copyrighted sound recordings as part of the process of training the model. Is downloading freely available audio illegal? Ask the 350 million Spotify users that use the free account. Ask every musician that's ever listened to or downloaded any songs to listen and learn and get better at their craft. Listening to music is not illegal. Downloading copies of copyrighted works, is that legal or not? Depends on what you're doing. If it's not available publicly and you're having to go to torrent servers or whatever to download movies and things like that, that's one thing. But downloading publicly available, openly available, freely available stuff on YouTube and Spotify that is being distributed for free, not in any violation of copyright, that's not illegal. Okay, there's a huge difference between downloading copyrighted movies and TV shows versus downloading streaming music that is being put out there for free. Big difference. While the complaint includes a variety of examples of outputs that allegedly resemble certain pre-existing works, and allegedly is a strong word, it goes out of its way to say that the complaint is not alleging that those outputs constitute actionable copyright infringement. So what they're saying is here that while the lawsuit has 665 examples of what they consider copies, the lawsuit is not stating that those copies are breaking the law or that those copies are copyright infringement. Understand the subtle difference here? They're not saying that Suno or users of Suno created copies of copyrighted material. The lawsuit is saying, the lawsuit does not specify that whatsoever. And it's obvious they can't, because when you listen to those attempts at creating pre-existing works, they're not the same thing. They're not even close. They sound similar in mood, and yeah, that sounds like 1 O'Clock Rock or Johnny B. Good or whatever, but it's not 1 O'Clock Rock or Johnny B. Good, etc. So Suno is arguing fair use. It is fair use under copyright law to make a copy of a protected work as part of a back-end technological process, invisible to the public in the service of creating an ultimately non-infringing new product. Flat out, Suno is saying this is fair use. We are copying this music for back-end analysis. They're not copying it to redistribute it. They're copying it as learning material, okay? Now we're going to get into history. Congress enacted the first copyright law in this country in 1791. In the 233 years since, no case has ever, not one single time, reached a contrary conclusion. Every single time the question has been presented, and it has been presented over and over and over again, the ultimate conclusion has been that making an intermediate copy of a protected work in the service of generating non-infringing outputs is permissible, not actionable. That's legal speak, and I'm not a lawyer, okay, obviously. So what they're saying is here, in the yellow, fair use, the courts have said in the past, it is legal to make copies of information, text, music, image, whatever, as a back-end technological process in the service of creating something new. And that's the way it's always been. There's plenty of legal precedent. Lawyers care about that. It's never been considered illegal. So Suno, I think, has a good claim here. They're saying, look, this has been done many times in the past. It's fair use. We got a 233-year court history. Intermediate copies of protected works are legal, not actionable. Actionable meaning we can sue you for it. So I think that's pretty solid. This lawsuit thus seeks a genuinely unprecedented result, a ruling that is actionable copyright infringement, not fair use, to have copied plaintiff's works as part of a process of developing a new technology, even though the ultimate outputs of that new technology are themselves non-infringing. In other words, the law has said you can copy things to study and use to create new works, but the plaintiffs, the record companies, are saying that, even though your stuff is not a copy, that was mentioned earlier, that, we're not saying that what you output is a copy or illegal, but what they're saying is that the downloading of the content is legal. And that's just not. This is fundamentally flawed, in my opinion. Let there be no doubt, the outputs here are, as a rule, non-infringing. The copyright statute speaks to this with clarity, and they talk about that. They cite it here. Congress made the public policy choice to immunize such new creations from copyright infringement liability so long as they do not themselves contain actual snippets of pre-existing recordings, which they do not. Interestingly, the very reason this statutory provision exists is because the record labels wanted it. Mic drop. Okay, so the section here in yellow says these do not contain actual snippets of pre-existing recordings. You know what it does? A lot of music that samples. Those are snippets. Those are actual copies of someone else's work that you have to get permission to use in songs. If you don't, you get sued. That's different because you're actually copying the copyrighted work. AI tools like Suno and Udio, they do not copy. They create new audio that is influenced and trained and based upon the rules of pre-existing works. And ironically, Suno kind of drops the mic here. The reason that law exists is because the record labels wanted it years ago. They talk about the history for a while. It's definitely a good read. I'll go past this little bit here. So fast forward to today, generative AI. The effect of this legislative compromise is that the outputs of tools like Suno, which do not reprise actual sounds fixed in any recording, they're not samples, they're not copies, are not and cannot be even prima facie copyright infringements. That's a legal term saying that they're actual copyright copies, duplicates, etc. The outputs generated by Suno are new sounds, informed precisely by the styles, arrangements, and tones of previous ones. They are lawful. They're not copies of existing sounds. They're brand newly created audio segments. They're not copies. I'm saying not copies a lot because that's incredibly important in this case. Suno's not a sampler. It's not a copier. It's reproducing sounds based on tens of millions of music songs out there. It is no secret that the tens of millions of recordings that Suno's model was trained on presumably include recordings whose rights are owned by plaintiffs in the case. They're saying it right there. Yeah, we've got copyrighted material in the training database. I've said it many times. I'll continue saying it. They're not reproducing copyrighted works. They're learning from copyrighted works, just like every musician in the world does. Suno's training data includes essentially all music files of reasonable quality that are accessible on the open internet, abiding by paywalls, password protections, and the like, combined with similarly available text descriptions. They're saying, look, we're not getting by firewalls. We're not skipping password protection. If something's locked and blocked, we're respecting that. We're only downloading stuff that is freely downloadable. So what do we got here? This is a lengthy session. I'm going to read this. The complaint describes fairly elaborate efforts. In other words, the record companies are saying, they're describing efforts to show that copyrighted recordings, a term defined to refer to the asserted works in the lawsuit, were specifically included in the data set that Suno used as the raw material from which its neural network extracted insights regarding how music works. For example, they say they inputted the full lyrics from the song Johnny Be Good along with a prompt describing it. Okay. They found that the output replicates the highly distinctive rhythm of the original's chorus and uses the same melodic shape on the phrases. These similarities are only possible because Suno copied the copyrighted recordings that contain these musical elements. That's right. They copied the music to learn from it. They didn't duplicate the music. They're recreating new audio based on instructions, just like any band at a bar is playing a cover song, just like anyone on TV or in a concert is playing, a song. They're not copying it. But the conclusion actually does not follow from the investigation that supposedly preceded it. In fact, even a cursory search on Spotify reveals literally hundreds of different recordings of Johnny Be Good. Consequently, plaintiff's argument betrays a profound misunderstanding of the technology at issue by suggesting that their particular version must have been in the training set because Suno allegedly generated an output that contains the highly distinctive rhythm of the original's chorus, along with the same melodic shape. Suno says so too to countless other recordings of that song. And to be clear, these are largely features of the musical composition, the rights to which are owned not by anyone in the lawsuit. So interesting how they're using examples in the lawsuit of music that's not owned by anyone that's suing Suno right now. So when plaintiff's lawyers prompted Suno with the lyrics to the musical composition Johnny Be Good, they not only flagrantly violated Suno's terms of service, which are designed to ensure that the product is used to generate new artistic expression, but the record companies also committed acts of infringement of those third-party publishers' rights. It's kind of a mic drop. They're saying, look, the lawyers or whoever on the team that recreated Johnny Be Good are taking lyrics from songs that not even they own, because Suno is saying that song is not owned by any of the companies in the lawsuit. So they're taking someone else's work, copying those copyrighted lyrics into Suno, the tool, which is a violation of Suno's terms and conditions, and then they're complaining about it, a song coming out that sounds similar. That's rich. That's really rich. Some more. When records first began to gain commercial traction in the 1930s, musicians aggressively lobbied against their use, warning that replacing orchestras with pre-recorded performances would leave real musicians on the human scrap heap. Oh, the humanity. When synthesizers began to gain popularity in the 60s, leaders of the American Federation of Musicians passed a resolution banning the use of the technology for fear that it would be used to replace instrumentalists. Did you hear that? The Musicians Union banned the use of synthesizers in the 1960s. It's all this emotional knee-jerk bullcrap. It's kind of just ruining the world in general, but in this musical world, it's really frustrating. These emotional, zero-tolerance, dramatic, breathless complaints. People just don't think. In the 1980s, a branch of British musicians passed a motion to ban drum machines in all recording and live work, arguing that such automatons are doing the musicians out of work. Bans, more bans. Zero tolerance. That's the stuff of hell, of communism, of socialism, of absolute opposite of freedom. people freaking the hell out and banning stuff. Oh my God. Sound familiar with what's going on in the world today? It sure does to me. More recently, the major record labels have made a standard practice of seeking to thwart competition from smaller independent labels using complex contractual constraints to prevent streaming services from leaning more heavily on smaller labels willing to license at lower rates. Shots fired. They're saying that record companies might be colluding or doing unethical stuff. Collectively and individually, the major record labels wield massive market power, and they have not hesitated to exploit it in fundamentally anti-competitive ways. This is not speculation. These issues have been adjudicated in regulatory proceedings. Suno is calling out the record companies for their past unethical behavior, unethical business practices, and they're exactly right. In the AI space, the labels have been even more brazen. On information and belief, they have sought to impose deal terms on a broad array of licensees, effectively requiring an across-the-board no AI policy, essentially trying to leverage their exclusive rights under copyright law to strong-arm music users into categorically avoiding artificial intelligence products. With respect to music AI startups, specifically, the relevant facts have not yet come to light, but there are certainly indications that the labels through their trade group, the Recording Industry Association of America, may have responded to outreach from potential commercial counterparties by engaging in one or more considered refusals to deal. So no AI policy. That's killing us in the sync world right now. Every library I know is saying no AI. I think that's an incorrect policy. I understand it. They're concerned that if some stupid ass decision comes down in the courts and they say that this music is illegal, they're going to have their catalogs compromised, and that's a huge headache. It's an unfortunate position that the libraries have been forced to begin to because of the litigious nature of our society. It's not, if I go and say, hey, create me an audio sample of an African instrumental loop combined with a German polka band with orchestral strings, and I get some really unique thing that never existed before, I can't use that sample in a trap beat or as a basis for anything because the libraries say no AI. Even though there's no way in hell that loop is going to infringe anyone's copyright. It's just this, I'm a little frustrated today. It's just maddening, the lack of rational thought going on in the world today, especially in the music industry. It's just, oh my God, fear is zero tolerance. Zero tolerance policies are almost always massively flawed. Yeah, soapbox, stepping off now. No one owns musical styles. Developing a tool to empower many more people to create music by scrupulously analyzing what the building blocks of different style consist of is a quintessential fair use under long-standing and unbroken copyright doctrine. Plaintiffs' contrary vision is fundamentally inconsistent with the law and its underlying values. They're basically pimp slapping the record companies, saying you're wrong. You're wrong on this side, and I agree with Suno on this completely. Fast forwarding here, Suno admits that constructing its generative AI tool required showing the program tens of millions of instances of different kinds of recording sources in order to derive statistical insights about them. You can't teach someone history without reading history. You can't teach someone about art without showing them art. You can't teach someone about music without showing them music. That's how it works. So Suno is admitting, yes, we downloaded copyrighted material in part of the tens of millions of examples of music that we used our tool to train on. But they're firmly stating that's fair use. That's fair use. That's fair use. They're not redistributing it. They're not copying it. They're analyzing it, just like musicians do. Fast forward again. There's some more stuff here. Oh, this is when they answer all the questions. In the complaint, there's paragraphs that are numbered, and so lawyers have to respond to each of the paragraphs saying, yeah, we did that. No, we didn't do that. No, this is stupid, blah, blah, blah. Do I have any more highlights here? Yeah, I do. Suno admits that its model is based on a machine learning model. Suno further admits that its model produces audio. Suno admits that its model is a type of computer program known as a neural network, which was constructed by showing the program tens of millions of instances of different kinds of recordings gathered from publicly available sources. By analyzing their constitutive elements, the model derived a complex collection of statistical insights about the auditory characteristics of those recordings. Suno admits that its training process includes additional further technical requirements. So they're saying, here's how the tool learns. We listen to copyrighted stuff, and we learn from it. Suno admits its model generates new music and existing musical styles using a complex collection of statistical insights regarding those styles that it has derived from tens of millions of sound recordings. They're saying, yeah, we analyze lots of music to create new stuff. Is that everything? I think it might be everything here. So that was a walkthrough of the answer to the lawsuit. I think Suno has a lot of good legal ground to stand on. There's precedent. Copyright law has been tested multiple times in the 200-plus year court history in the U.S. The record companies have proven unethical in the past with collusion, strong-arming smaller businesses, etc. Fair use is clearly claimed in this lawsuit because listening to music is not illegal. The real crux is whether or not the jury is persuaded that these musical examples are somehow dangerous to the music market. They're going to devalue the music market. They're going to hurt record company profits. They're going to hurt musicians, which, when you look at it from a rational perspective, is laughable. And like a lot of folks are saying, look, this is just a record company saying, hey, you got a cool thing out there. We'd like to get a piece of it. If we don't get a piece, we'll shut you down. We'll see how it goes. Let me know what your thoughts are. I've said some pretty straightforward stuff in this video here. It's early in the morning. I'm tired. I'm cranky. I'm stressed. That's what happens in the world these days. But I think Suno should prevail. Will they? Depends on the court system. And I'm not confident. Have a great day. Go make something great.